Good morning. I'm Steve Smith, chairman of this Board of Trustees, and appreciate everybody's attendance. And this morning, we're going to have a thorough, bright, and on-time committees. And Pete is subbing for Pam, who couldn't make it today. So, Pete, take over.
Thank you, Mr. Chairman. I'd like to call to order the Academic Affairs, Student Life, and Athletics Committee. And I'd like to begin with the roll call, please.
Thank you. Trustee Baker.
Here.
Trustee DeLay.
Here.
Trustee Jacobs. Trustee Martin.
Here.
Trustee Smith.
Here.
Trustee Wright. Trustee Eisenberg.
Here.
General Huber. Chris Massaro.
Here.
Mr. Chairman, we do have a physical quorum present.
Thank you. We distributed the minutes of the last meeting. I would entertain a motion to approve the minutes of our last meeting.
So moved.
Second.
We do not need a roll call vote, correct, Heidi?
Correct.
All in favor?
Aye.
Opposed? None. Behind tab 2, we're going to discuss approval of tenure and promotion. I'd like to pass to Mark Burns.
Thank you, Chairman DeLay. This is slightly out of sync, but it's very much the same sort of approval that you did in June. This is a faculty member who has gone through the entire review process, and Dr. McPhee recommends approval of tenure and promotion. Be happy to answer any questions you might have.
Any further discussion?
So moved.
Second.
All in favor?
Aye.
Aye.
Opposed? None. Behind tab 3, another action item, the approval of a new policy, Policy 90, Athletics Integrity and Conduct of Athletic Staff. I'd like to ask Janae Stevens, Assistant Vice President of Compliance and Enterprise Risk Management, to speak on this.
Thank you, Trustee DeLay. Policy 90 was developed out of a summer project and group that was initiated by President McPhee and headed by our Vice President, Deb Sells, to address coaching integrity and coaching conduct, as well as to provide additional information and procedures for ethical conduct in athletics. It also allows for student athletes to proceed with an independent and objective party and actually a manager, compliance and risk manager, who will report to my office in the event that that student athlete decides that they're either uncomfortable with the current athletic procedures for student athlete grievances, or they would just prefer to have an independent party look at their grievance. And so that is the purpose of this policy. The policy also outlines disciplinary action if athletic staff, including coaches and administrators, violates the policy, but it does provide an independent, objective review of student-athlete grievances, and this also addresses concerns that parents have voiced at our board meetings in the past.
Thank you.
That concludes my report.
Discussion?
I have a question, if you don't mind.
Yes, ma'am.
In section
Trustee Moore.
4, part G, on page 14 of that document, next to the last paragraph, the sentence that begins, student contact with MTSU counseling services, confidential information about appointments, et cetera, except as permitted by law and required to protect the life, safety of the student athlete. The required by law will cover any needs that we would have to protect others than the student, correct?
That is correct, yes.
Okay, thank you.
That
Just
is.
wanted to check on that.
Yeah. Any other questions?
Any additions? additional discussion?
We got the athletic director. Have you signed off on this, or?
Yeah, I was part of the group that formulated this.
Good. Move for approval.
Second. All in favor? Aye. Opposed? None?
Mr. Chairman, I'm sorry, who made the second on that?
Me.
Okay.
It's kind of a quiet second, wasn't it?
Yeah.
Thank you.
Thank you.
Our next item is the approval of a rule or policy revisions to Rule 0240-07-05 student conduct and Policy 540 student conduct. Our presenter here will be Heidi Zimmerman.
Thank you. Well, this is deja vu all over again, right? You have seen this policy a couple times, and the reason it is back before you is that there is just one additional revision that is being recommended by the Office of Student Affairs to both the rule and the policy. Because this has to be promulgated as a rule, we want to be sure it is right before we send it through the process. And speaking of the process, we are now taking this through a different process rather than the proposed rule process, and I won't get into all the details unless you want to know them. We will be promulgating rules through the rulemaking hearing process, and so we will schedule that rulemaking hearing sometime in the spring. But what is before you now to be considered and voted upon are just these, just this single revision to the policy and to the rule, unless there are any other questions or
Ms.
requests for
Zimmerman,
revisions.
explain what you just said. We're going to approve something now, but it's not going to be promulgated until the spring.
That's correct.
Why
Sure.
distance of time?
Sure. This policy and rule, because it deals with students, is the responsibility of this committee. And then the rulemaking process requires that the board hear the rulemaking. And so what we will do is schedule that hearing for the spring board meeting. We have to give at least a 60-day notice that has to be filed with the Secretary of State's office. And so it is a very long and confusing process, but
I would agree with that.
that is why.
Mr. Chairman?
Will there be, in the rulemaking, when we have it in the spring, will there be further discussion on, A, B, or?
There well could be, sir. What we'll do is provide a notice to, this will be part of the public notice. And so it'll be a process where anyone can come forward and make suggestions or questions or pose questions to the board. And then the board will take those into consideration and look at staff considerations as well, and either can approve it at that point and it moves forward, or the board may say, staff, we want you to look at further revisions or consider some of the comments made.
So today's not the final verdict?
That is
No
correct.
pun intended.
Right.
A couple in the weeds things, because I've been interested in, like we all are, in trying to get this exactly right. One minor one, and it may be on purpose, but on page 33, it appears that the accused gets 4 days legal notice of a hearing, and the victim gets 5 days. That's on 36.
Page 36.
It's 36.
36 in the middle, 2A is an apple. So I don't know if that's on purpose or not. And while you're looking at that, if I think what gives me a tummy ache the most is serious crimes that would ultimately require jail time. Date rape versus plagiarism. I mean, and I think you probably, I'd like to see you either reword it to say, this is timely to high crimes. You both get 10 days notice. Because 10 business days isn't long to prepare yourself if you've been accused of something that would ruin your reputation and get you jail time. I know they wouldn't get jail time from here, but would end up, are there any, because I haven't compared the first one with this one. Are there any do you have a red line version? I mean,
I believe
or
that's,
is there one there and I just didn't?
there is.
Okay.
It starts on page 64.
So it's a blue line.
Well,
Yeah,
that's
yeah,
true,
yeah, yeah,
yes.
yeah. Okay, I got it. I'm sorry. Well, before we get to the final verdict, if it's not 4 versus 5, I think it ought to be the same. And I would suggest that I'm not sure how you describe the offense, but if it's an offense that might be a felony, then I think you need more time than that.
Well, sir, as you recognize, there is a distinction to always keep in mind that what this process is not through the criminal judicial process. This is a disciplinary process. So anything that, would be, the courts would have to determine whether there was a finding of someone being charged with a felony or a misdemeanor. And in terms of the period of notice, perhaps Dr. Sells could speak to this better, or she may want to call her lifeline, but a party can always request an extension of time, and for good reason. If they need more time to prepare, that will certainly be considered.
Well, I think at least they ought to be the same. And on a serious offense, I know but if you get kicked out of school for double parking, I don't think that carries the same connotation as getting kicked out of school for date rape.
Well, yes,
And I've been silly on
Sure.
both sides.
If it's a matter of a student being, where the intention is to suspend or expel the student, then the student has the opportunity to elect a Uniform Administrative Procedures Act hearing, and that entitles the student to quite a lot more due process, including being represented by an attorney, being heard before a panel or an administrative law judge. So there's a lot of points to this, whereas someone may be just getting a reprimand or a written warning, the process wouldn't be as detailed. But if we are talking about a serious offense where there's a suspension or expulsion involved, then the student does have the opportunity for a more detailed.
I'd like to see 10 days on that. And I'd like to be some differential between a life changing for both parties and a permanent scar versus I looked at Mark's paper during the test, or plagiarism. I mean, they're all serious. I've got that, but one of them doesn't carry in my mind. So a couple of others that are, what is the qualification for an administrative judge?
I would have to look at that, check the statute for that. But here, we only use licensed attorneys, people on our staff who are attorneys. They may not be in my office, and they aren't in my office, but we have many, or several anyway, people on staff who are attorneys, and we utilize them. They also are trained each year before they hear cases.
To the point of a criminal attorney on staff? I mean, if we're talking about the word that he used, serious crime, help us out there. I mean,
Again, this isn't a criminal proceeding, this is a disciplinary
well,
proceeding.
if you talk about rape, that becomes criminal.
Not in the sense that we can imprison you for a
No, we
violation.
can't, right. But you're being brought before of
Yeah.
accusation.
Yes.
I'd like to see a little bit more qualification for whoever is appointed to be the administrative judge. Because, I mean, I know what an ALJ is, but this isn't referring to an ALJ. I mean, this isn't referring to administrative law judge like Department of Agriculture or like, this is referring, I think, to an administrative person that we would appoint.
If you can
And-
give
and
me
then
just a few
last,
moments.
If we can debate it again, Mr. Chairman, if I might take one more minute, because I've worried about this. And what are the qualifications of the investigator on a serious crime?
Again, sir, we're not talking about criminal offenses.
It's a serious crime if you get expelled from school for date rape.
Well, if I can make a comment, I believe I'm correct in saying that if it is an actual crime, all of the civil proceedings happen before they get to this process. So the guilt or innocence of the crime itself will have been taken care of by the civil function. Is that not correct? And then we take the results of that and factor that in?
No, not
We're primary,
necessarily.
according to what I read.
Okay.
We don't have to. We have that option, but we don't have to. Mr. Chairman, policy 110 is on our cases to be heard before Administrative Procedures Act, and here are the following individuals may serve as administrative judges or hearing officers. 1, a person licensed to practice law who is not employed as an attorney for the institution. 2, a former state, county, or municipal judge or former federal judge or magistrate. 3, an employee of the university who has been trained to conduct contested cases but who does not provide legal representation to the university. 4, an employee of another public institution of higher education who has been trained to conduct contested cases. Or 5, an administrative law judge or hearing officer employed by the Office of the Secretary of State pursuant to TCA 4-5-301D to hear contested cases.
Heidi, aren't these often faculty members who have law degrees who serve in, or at least sometimes?
I know there are at least 2 or 3 that we utilize who have law degrees.
So they're doing that outside their normal scope of work. It's outside their teaching, but it's part of their service function.
I guess what I'm saying, not to be adversarial, is it is outside their scope of work. And if you, on a serious crime, you would at least appear before somebody that makes a living judging.
And that's what will happen in the criminal courts. They will appear before a judge who is trained in the criminal.
We debated
Jurisprudence.
criminal, and it's not criminal, but if it's murder, do we hear these cases? Well, I mean, I'm being facetious, but
I don't think we would have to, because that person, I would imagine, would be imprisoned and
Let me say just a couple of words about what we're trying to do as an institution. The decisions we're trying to make, and I'll have Sarah jump in here if I get too far into the weeds. The decisions we're trying to make are about whether or not the student poses a safety risk to the university, and whether or not we need to be taking action to enforce our campus standards with relation to the students' actions. It is not a criminal proceeding. They may be going through two processes simultaneously. We may be making decisions as an institution about whether or not we should maintain this student's presence on our campus at the same time that the student is going through a criminal proceeding, which is determining whether or not they are responsible for whatever it is that they've been charged with by the state. And so those are two separate processes that are going forward. On our piece of the process, what we're having to try to balance out is the safety of the campus, the rights of the student who may have been the victim of whatever the issue is, the alleged victim, and the rights of the alleged perpetrator. So we're trying to balance all three of those and make a decision that protects the alleged victim, the alleged perpetrator, and the campus writ large. And those are different standards, different priorities than the criminal courts would have. Our biggest step that we could take is separating a student from the institution, either temporarily through a suspension or permanently through an expulsion. That's the extent of our reach. And anything beyond that would go through the criminal courts. And they have been found legally to be okay with having us have two separate processes happening simultaneously. In the case of a murder or something that lands a student in jail, very often then everything with the institution just gets put on hold because the student isn't available to participate in any kind of hearing process. So we put everything on hold. The student may be put into a temporary suspension status until they're free from jail to be able to come and participate in some kind of hearing process with us. But very typically, whatever happens in the criminal court sort of solves the problem for the university. The university is trying to make sure that the environment remains safe, and if the student ends up in jail, it's no longer.
I'm 99% I do fear the accused rights, and I would prefer that on date rape, they would do the same as murder. You'd give it to the civil, because in baseball, we argue silly things to clarify a rule. So if we kick a person out and then the court finds him innocent, I would think we would be liable. I mean, I would think we would have serious repercussions if we accused her or him of date rape and kick them out, and then they have a full trial and find out that it's not. And we've already done that. They're not going to hear a plagiarism case. I mean, just like when Brenda brings a $5 case for credit card, they don't hear them. But I'm asking that you might consider on a serious crime where I know it's not jail time, so why not take it to the law and let them decide and do just what you suggested. They're not going to go to jail on the first day of that. It may be 2 weeks later or a month later. I've got that, but at least let's don't get in a position where we've wrongly punished somebody that is, I assume if you're over 18, it's permanent to your record. And that's pretty serious. Tom wouldn't hire somebody that had been kicked out of school for date rape. So before we go all the way, I'd like to ask you to just think about, one, let's get the days straight, one way or the other, and two, is that a capital offense? Is date rape a capital offense? It's not. Deb says no. Well, I'd like to find some way to describe the offense other than that one, murder or assault with a deadly weapon or manslaughter, or that we let the courts, you suspend them temporarily and reserve final until they say there's not enough evidence here, we're going to mess with this, or you're guilty or innocent.
There are going to be a couple things that the board will want to consider on the other side of the equation. One is we have some federal obligations from the Department of Education for the kinds of protections that we need to offer under several rulings that they have found that apply to the university. So that's one piece. We have to maintain our compliance
Sure.
with federal obligations. The other piece you'll want to remember as trustees is that there will also, in a case, should one come forward, you will also be under tremendous pressure, not only from the families of the accused, but from the families
Sure.
of the victim. And there will be some expectation that the campus does not suffer under any kind of sense of danger by letting somebody continue to operate on the campus when we know that legal cases can drag on for months and sometimes years. And for a student who has brought a charge and believes that they've made that charge in good faith, to have to continue to attend classes and be in with this person, you as a board will get a lot of kickback about that from families. I'm just sharing that with you based on our experience, that you are always trying to balance out the rights of the two people involved in a situation.
Could you temporarily, just what you suggested in murder, and that is, you wouldn't kick them out until after the trial's over, but you would temporarily suspend them? If they
We
do
might
charge.
kick them out before the trial is over. If a trial is dragging on for 2 and 3 years, and if we have sufficient evidence, again, it's important to remember that the standard of evidence for a campus is going to be different from the standard of evidence in a
Right,
criminal case.
This is majority rule. It looks like there is we have expanded the board to 8 people, though. There was, I think, was it 3 or 5 the first time? The jury?
I'm sorry, I don't understand your question.
Well, we appoint X students and X this to decide,
Committee, I think.
yeah, but it's a jury,
Yeah.
right?
Well,
The disciplinary, you're talking about who does
They're making the-
who makes
they're
the
making the judgment.
the decision. I don't know what the number on a
It's
disciplinary
deciding
committee is.
committee then, if it's
Right.
not the jury, and it's just preponderance, so it's 5-3, not unanimous, which it would be on, I'd just like to ask, and I won't take any more time, but I'd like to ask that you look at the days, and that we give more time, not less, for notice. And it doesn't say, but maybe it does say, I assume there's some kind of legal service that has to be, because if you gave me notice and I didn't get my mail, I mean, on something serious, and they're all serious, but I'm talking about something life-changing forever.
Well, and it may help to define that for you if you understand that, as Heidi was saying, if a student's enrollment at the university is in question, if they are to be suspended or expelled for any offense, they immediately get kicked into this process where
Sure.
they can request a TUAPA hearing where they get all of these expanded rights. So we don't really have to define it as a sexual crime or a capital crime or whatever. Anytime their enrollment at the institution is in question, where that potential outcome is a suspension or expulsion, they have these expanded rights. So that's built into the process
And
now.
that's statutory. The UAPA hearings are governed by statute that set out different timeframes that must be complied with.
So there's a legal way to serve you.
I'm sorry?
To
How do you-
provide
how do
notice
I
of
get
what's going on.
service,
Yeah, it doesn't go through a process server, but students understand at the point of enrollment that all of their official university correspondence will come via email. We deliver via email. We also can have my office have them come and pick it up directly at the office. The claim that they didn't get their notice is not something I don't think I've ever heard. Okay, so email, hard copy, and pickup is how we make sure that they get it.
I'm going to say, Uncle, I'm going to give in, so it won't go on forever, but on something that is serious, I'm talking about mark your life. Service might should be more guaranteed. And notice might should be more, and it might be that we ought to handle them different than plagiarism, which is, I'm not demeaning, but it's not date rape.
Right. I'm trying to reassure you that the distinguishing factor is not what the potential crime is, it's what the potential ramification from the institution would be, and anything that propels them into potentially being suspended or expelled will take them down the road of expanded, to the greatest degree possible, expanded rights for the person who's been accused.
Trustee
I guess my argument is if I'm convicted of one of those, or not convicted, but if I'm expelled for that reason, it's a much more serious, you're still out of school, I got that, but it's a much more serious charge. And I'm happy to go on to what's next. I'm just, before we, so I'd like for you to look at, are there high crimes? And are there, I mean, in every other, there's bad ones and really bad ones and not so bad ones, and some get suspensions and some go to electric chair. And I'm not sure that somebody accused of double parking should notifying him by email or her might be fine. But on a serious one, I'm not sure.
Mr. Chairman, let me say that the notice, there is a provision for notice. It is on page 22. It has been vetted by the Attorney General's office. They have looked at that, and they have said that this process for notice for student is compliant with the law. And so, and this notice is provided to a student regardless of whether it's the lessest offense or the greatest offense. The notice process is always the same for any student charged with a disciplinary offense.
Samantha, did you have a question?
I was just going to say, I don't know if this is helpful or not, and please correct me if I'm wrong, but I have been on the University Rules Committee. Also, Ms. Sudak, please feel free to jump in. They have an option, I believe, of how the student that wants to have their process heard. They can be heard by a student judicial board, they can be heard by the committee, or they can skip all that. And I believe some of the types of offenses that you're referring to automatically go to those higher ones. So they do have a variation in if they're accused of double parking, they can have their case heard by students versus more higher officials, I guess, is what I don't know if that's helpful or not. Excuse me.
Well, one of my questions was, you can choose mediation, I saw that.
Mm-hmm.
And I wondered what the
Depends on the offense, but yes.
Is that right? So there is a difference in offenses on mediation?
State law dictates we can't mediate sexual assault cases.
Right, there's a federal.
I can't hear thunders.
I'm sorry, there's a federal requirement that we are not allowed to mediate sexual offenses.
I don't
Well, I
remember
mean,
the detail.
it's kind of my point, and that is, if you can't mediate that, should that be done?
Don?
I don't remember all the details of this, but I think it was the University of Virginia that had a sports team. What was it, Chris? Which
It
one?
was
Lacrosse.
Duke.
Lacrosse.
Duke
University
lacrosse,
of
so I'm
Duke.
way off. Duke lacrosse. But anyway, if we had a similar situation where a team was ended up being wrongly accused, but it took months to decide that, do we feel comfortable? And during that process, I think the image of Duke was hurt, those students were hurt, so forth. Do you feel confident that our process would handle that better and would minimize any image, reputational damage to the university and to the students?
And let me just say, in that particular case, I believe the university essentially convicted these people long before the courts wound up exonerating these people. Isn't that correct?
Right, that was a fairly unusual case, but certainly part of what happened there was the public got very involved in making demands of the institution. I feel pretty good about our process simply because there are so many different parts of the university that review and help us make sure that a situation is getting the broadest possible examination. So Janae Stevens in our office that pays attention to whether or not we're in compliance would be following along with our process. Legal counsel follows along with our process. The judicial office follows along with our process. Title IX office follows along with the process. So there are lots of eyes that are working together, reviewing what's going on, and before it gets passed along to another area, gets a chance to weigh in. And so I feel like we would be in a much better position. I also think just nationally, a lot was learned from the Duke situation. A lot was learned.
I think they
And
have
many
one with
institutions
Michigan
do
the
things
same
very
way.
differently. I'm sorry.
So I just have a question to follow up on Tom's. So what is different, what safeguards are in our process that were not in the Duke process that prevent that kind of thing from happening here? What specific types of safeguards are in our process that would prevent that kind of rush to judgment that occurred in those cases?
And if I can add a comment on that, that's sort of why I mentioned the university waiting for the civil process to complete before taking their own action, because the civil process has a whole lot more resources, especially with regards to gathering evidence and determining guilt and innocence on a regular basis than a university would have in that type of crime. And to me, one of the lessons learned from the Duke problem was that in the best interest for the community, the university overstepped its bounds against the individual, and that balance was out of whack. So I understand protecting the community, and as a regular member of that community, functioning in that community, I certainly don't want awful things happening within the community. But I also think that for the good of the university, we have to learn from that lesson that Duke learned, and I would like to think one of the lessons learned would be in the case where we can't directly determine guilt or innocence, we shouldn't a priori go ahead and do it anyway.
Okay. Well, in part, and Heidi can correct me here, there are, again, some federal statutes that won't permit us to simply wash our hands of a situation and say we're going to wait for the outcome from the courts. We are required to step forward and take some action. I don't know enough about the ins and outs of exactly how the Duke situation unfolded. My guess, were it us, is that we would be looking at a range of offenses that may have happened in that situation. Again, I don't know all the details, but if there were, for instance, alcohol infractions, drug infractions, assault infractions, and a rape infraction, we would be looking at all of those. And a university would be within its rights to take action on any or all of those. And so, again, I don't know the details, but in a case like that, those students may have been removed from the university related to some but not all of those charges. And then what the courts do with the actual criminal statutes is an entirely separate matter. So I guess I'm concerned that I wouldn't want us to believe that simply because a university has suspended a student and a court doesn't take action on the most grievous of the infractions, doesn't mean there wasn't enough at a more minor level for that student to have been removed from the university.
But I do understand the desire to make sure we have appropriate safeguards. So let me ask this question about this action item to make sure I clearly understand it. This action item today is primarily a procedural action item. However, we have an opportunity before the board votes on this and when the board votes on this in the interim to make changes or revisions in here. Is that correct?
Sure. I mean, what the committee votes on is a version of the revision. It makes that recommendation to the board, but then the board has the opportunity to review and revise it as well. And that will come at the rulemaking hearing, which and the comments that anyone from the public may make may also cause you to request additional revisions.
So that rulemaking hearing, I believe I heard you say was in the spring. Is that correct?
If this passes out of committee, then I propose that it will be set for the next board meeting, which will be not the December board meeting, but the spring board
The
meeting.
spring board meeting. So I'm asking this, is it possible, you need an action taken on this, either approve or deny. Is it possible for this to pass now, but with the the understanding that we want to make sure that before we vote on this at the board meeting, we make sure we feel comfortable, we get the appropriate safeguards to protect the rights of one of those sort of rush to judgment matters, or one of those things that permanently mars someone's permanent record. We want to make sure that we don't overstep, I guess is what I'm saying.
Is this the first reading, like if it's a council bill? I mean, is this the first reading and we're going to have one more before it's official?
Well, actually, of course, you all have passed this out of the committee before. And what's before you now is really just a consideration of that one revision, although that doesn't mean you can't go back and make additional ones. But I guess that analogy is correct that, yes, if the committee, if it passes out of committee, you approve it, that doesn't mean that no further revisions can be made. The board looks at it, the board, all of the members of the board look at it, and of course will vote and can make motions to revise it. So this is not set in stone, if that
Today,
responds
this
to
is
your
before you because we're asking to change the definition of aiding and abetting to,
Well, the title,
the title of aiding and abetting to
joint responsibility.
joint responsibility. That's the only piece that we have brought forward
You've already
today.
approved everything else.
Department of Education is working on this, but they've been working on this 18 months.
Yeah.
I mean,
At least.
and I think it'll likely be different than it is.
That's possible, and if that comes to pass, then we will come back with revisions to comply with whatever
Mr. Chairman,
changes
I'll
are made.
move to move this forward as long as our minutes reflect the points of the different board.
And I did have one or two other questions, but you can act on Steve first if you.
Okay, so we'll entertain a motion. Do we have a second?
I need to ask one or two more questions.
go ahead.
I know you said that the retitling of this was what was important, but I was looking at the blue line part, and I noticed that the adjustments for the definitions of intoxication and alcohol policy, is that?
Right. The reason we debated how to present this to you all, the reason that you will see more blue line changes is because that was never effective, because we're still going through this process.
Right.
And so you've already passed out, voted on, approved every revision except the current one to change the title of aiding and abetting to joint responsibility. But we went ahead and
Left the
provided
blue line
the
in.
entire red line for you all because that has not yet become effective.
Right.
I'll withdraw my motion.
And I tell you what, thank you, because I did not understand that.
Sorry.
Doing my homework, the transcript writing of the state's writing in hours is completely different. I mean, it's hard to follow. I mean, I guess much better print on a university print versus state print. It's a hard flow to study this.
And we have to.
And be serious about our homework and what we're talking about today, so.
The rules have to be, are standardized according
Pretty
to
obvious,
the
yeah.
Secretary of State's
But it's not friendly.
requirements.
So, and my last question was in section G, which presumably came forward.
Trustee Martin, what page are you on, please?
Well, it says page 21 of 25 at the top, it's page 84 at the bottom. Section G5.
I am on page 85.
84.
84, I'm sorry. All right.
Okay. Nothing in this section, G, prohibits an attorney for the university from providing legal advice to multiple university employees who serve in different roles in the process of disciplining a student. And I thought that was confusing, given the title of the section was separation of functions. And so we were separating the functions, and then we didn't in the last sentence. And just a comment on that would help me.
The separation of functions addition is added because of a statutory amendment from 1 or 2 legislative sessions ago. And so this is lifted entirely out of a statute.
Even Section 5?
Yes,
So there is no, I mean, we still have protections about conflict of interest within the vertical
Absolutely.
alignment,
yes,
even though, in spite of that Section
yes.
5 statement. Okay, thank you. That was all I wanted to ask.
So I believe Trustee Smith withdrew his motion. Is there a motion to approve? Can we defer this?
You could defer this through a motion.
Is there a motion to defer this?
Well, so we get a vote. I'll put out a motion to approve pending, my understanding is that you've got a 60-day public comment period coming up on this?
No, this has
Yeah.
already been out for campus comment.
Okay,
What will happen if this passes out of committee is that I file the rule with the secretary. Well, first I'm going to take it to the AG's office for another look. But at least 60 days from the spring board meeting, I have to file with the Secretary of State the notice of the rulemaking hearing, and then that is published. We send out notice to any interested stakeholders so that anyone who wants to appear at the rulemaking hearing, which will be, it's in March, I'm sorry, I don't have the date with me, can appear before the board to make comments or ask questions.
Pete, why not?
I'm sorry, was that responsive, to your, Trustee Martin, to your comment or question?
well, let me phrase it this way. My understanding is anytime we want to look at a policy and revisit a policy, we can revisit a policy.
This is a rule, though,
And-
what she's
and
proposing.
yet
not
you're
policy.
proposing-
If it is a Board of Trustees approved policy, yes, which this is.
Okay. So in the interest of moving things along, because we have to have coverage in this area, I can go ahead and propose that this be passed. We either pass it or we don't at this point. And the board as a whole will bring it up in the April meeting for final validation anyway, as a recommendation from the committee, if it were to go to that point. And we could revisit as a whole board some of the concerns we have, and we could hear from you some of the reasons why we shouldn't have concerns.
And let me say, just to confuse us more, and my understanding of the rulemaking hearing process, we haven't had to do this heretofore, is that if what is filed with the Secretary of State's office in that 60-day notice period, if the board votes on anything that is substantially different from what is out there, we start all over again.
Yeah,
So that would mean if we make a significant change, if it's a change to a title or a comma or some minor editorial thing, that will be okay, we can move forward. But if it's anything substantive, then we start the process all over again.
And while the process has started over, we revert to whatever is in place right now.
Right, which we're doing right now. We do have a policy 540 in place right now under which the Office of Student Conduct operates.
So the only change to that policy that's currently there is the change of the title. Is that correct? All this other blue line has already been approved.
It's been approved by you all, but it is not effective. That's why we left it in. Because we were moving forward, and then we had this change of process, and then this additional minor change. So we just said, let's just hold it all. Let's get it right the first time and send it through, instead of having to go back again.
So Pete, I'm
Well,
not.
it was confusing.
I understand.
So to be clear, it would be, the only thing being voted on today is the red line changes being made, marked in here. And if it wanted to be revisited later, it could be revisited later, but the only thing being approved or denied today is the actual red line editorial changes, correct?
That's what is before you. That's correct. That's what's before you because you've already approved every other red line change. So what specifically you're looking at today is that one section title change. Again, since we're going through the trouble of doing all this, we wanted to make sure we had everything correct. And we're having to start over essentially because of the rulemaking hearing
Trustee
process.
Boyd?
Pete, I'm not a member of the committee, so I can't make a motion or second, whatever, but I would make a suggestion. It sounds like there is discomfort with this, more so in I think what Mary said earlier, that we would like to hear some assurances that we feel confident that we're not in a Duke situation, maybe is to summarize it there, or a wrongly accused person gets damaged significantly for life because we have taken some action. So to give us some comfort, so maybe if we could defer this and have a further discussion with the staff, and I appreciate the staff and all the work and comments have been very helpful, to come back at the December board meeting, and if that's allowable, and address those concerns around the change.
So if I understood Trustee Eisenberg, if we defer this today, we still have a policy in place, which is the policy that we currently have in place.
Yes.
We've just not adopted any changes. So a deferral does not prevent, we already have a policy in place. That policy remains in place, and that gives us the ability to study this more.
What you may want to consider is passing this to the board and letting us address your concerns in the interim, so that if there are any changes that can be made before December 10, those can be made and voted on. No, I'm sorry, we still have to do the rulemaking hearing. So that the next time the board would see it would be in the spring meeting.
April.
But if we passed it on now, the board could discuss, you could inform the board with whatever we informed at the board meeting that would partially address this, and that would not, and that might make it easier to pass it on to the spring meeting after the rulemaking.
Yes, I think that's actually where I was headed and got myself confused.
Right, right. So
That if you would submit your areas of concern that we can address at the December 10 meeting, perhaps that would.
I think areas of concern are because of the length of the document and because of a lack of an understanding of the parallel processes. So maybe a flow chart or something might address things. The concern is not with changing the title. The concern is looking at some of the blue lines that were left over from previous things. So I would propose I vote that we move it forward. Then that gets it on the table to vote on. We can move it forward or not, but at least we'll have a decision.
That's what I was, I think, trying to get at, Trustee Martin. The red line is the only thing that would be changing. The blue line stuff is not changing
That was
as it goes
previously
forward.
passed.
So the stuff that's being voted on today is not the problems that are being addressed. So I think in order to get the problems addressed, we need to get the revised version that they're looking for to be completely moved forward in order to address the problems as a whole, not the problems that are specifically being addressed today.
So we have a motion on the floor by Trustee Martin to approve this with the realization that we as a committee have a desire to make sure there's further study and understanding of the safeguards to make sure we're comfortable with this at the time the rulemaking is generated and at the time we wind up voting on this as a board in April. So the motion on the floor is that we approve this. Is there a
So let me make sure that staff understands the wishes of the committee. You're going to move this forward. We will attempt to provide responses, information, make a presentation at the December 10 board meeting. If the board is satisfied at that point that their concerns have been addressed, then I will go ahead and set the matter for a rulemaking hearing for the spring board meeting. Is that essentially?
Yes, and so I think the concerns are clearly that we don't make a rush to judgment. And so I'll oversimplify by simply saying, we want to make sure that there's safeguards in our policy that have not been in other institutions' policy. The Duke example was used. That we want to understand and make sure we're clear and we're comfortable with the safeguards in our policy. But the motion by Trustee Martin was that we approve this. Is there a second? It appears there's no second for this motion.
A question. When does this go to print in the student handbook?
When it becomes effective.
Okay.
And that will be when the rule is approved.
So the student
Because the-
handbook changes by digital or
After
changes by
After April's what you're
print?
saying,
After-
if it gets approved. then.
Well, after we have our rulemaking hearing, then it goes to the AG's office for their formal review and approval. It then has to be heard before the Government Operations Committee, and that, again, is several months out. So it could be, if we're on schedule, it could be summer. I haven't looked at the calendar, but to figure this out, but it could be summer or fall before our rule becomes effective, and then meaning our policy can become effective.
So if we approve it, it will take as long to undo it as it is to, once it gets to the AG's office, that process will take as long if we decide to change policy as what it's taken to approve.
Well,
right?
I would suggest we not send it to the Attorney General's office until
okay.
we are satisfied that this is
got it.
what we want to send forward.
Mr. Chairman, it's just point of order because I'm confused about committees. I'm a little late bringing this, but I asked Mark, and is Mary a member of this committee?
I'm sorry?
Yes.
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 Well, she hadn't been approved and voted on by the board. I mean, I've asked her to serve on every committee, but just like Tom's not a member of audit committee. He gave the report last time, and I'm thrilled, and I want him to be, but I've been informed that he's not. So do we have a quorum even?
Do we have a quorum? Yes, sir?
Well, so Mary is a member of the committee?
Yes, sir.
And when did she get voted on as member of the committee?
She became a member of the committee when she was appointed to the board.
Well, I appointed her, I mean, that's my duty, to appoint committee members.
Yes, sir.
And I did, but I've been informed that the board has to vote. Is audit?
The board
committee-
has to vote, I'm sorry, the board has, I'm sorry for interrupting you. The board has to approve the audit and compliance committee members and chair.
The rest of them don't, just if I appoint them, they're on it.
Yes.
Good. On to what's next.
So we have a motion. Do we have a second of that motion? It appears we do not have a second of that motion. Procedurally, how do you,
Well, if the board does not approve it, I mean, if the committee does not approve it, then it will not go forward. We will, I guess, go back and try to address your concerns and present something at the next committee meeting in the spring.
okay. So this item was not approved by the board. To tab number 5.
I think, though, it might be best
committee.
because this
By the
is an
committee.
action item that we do have a motion.
Well, and that's why I made the
It
motion.
just fails
the
for lack of a second.
But we still need
I
some,
thought it would be cleaner to have a motion and a second and then a no vote than just an emptiness.
I guess if someone would vote that that the committee does not approve and wishes it to be further studied
I can
and
do
brought
that.
back before the
I
committee.
make a motion that the committee does not approve. I'll change my motion, my previous motion. To get on the record, I'll change my previous motion that the committee not approve moving forward with this document.
Is there a second?
I'll give you a second.
So how do you ready to call a vote? The motion has been made.
The motion has been made that the
we do not
committee-
approve this.
All right, and who
And there-
seconded it, please?
Trustee Baker. All in favor of the motion made not to approve this? Aye. Aye. Any opposed?
No.
So Trustee Martin votes no on that motion. The other members of the committee voted aye on that motion to not approve this.
And those will be the weirdest set of minutes that you've ever read.
Absolutely.
Then we have 3 ayes and 1 no.
That's correct. Where's Pam when we need her? To tab number 5, please. The next item is not an action item. And I would like to ask Mark Burns to speak on this item. It's an informational item only.
Yeah, thank you, sir. If you'll remember at, I think the last committee meeting, we had some discussion about open educational resources. This is a national movement that is taking place designed to really address the problem of the high cost of textbooks, which can be enormously expensive. And so I asked Cheryl Torsney, Vice Provost for Faculty Affairs, to get together a committee to look at this, which she has done, and I'll let her introduce a couple of our faculty members who've been active, and they'll give you a brief presentation about what we're talking about and what we're thinking about doing. So Cheryl, thank you.
Thank you very much, Provost Burns. We've been working on this actually for about 2 years. This is a huge national movement. Suzanne Mangrum from the library and Ryan Korstange from University Studies have been leading this initiative. We have been investigating thoroughly, and we would like to give you some more information about open educational resources. So, take it away.
We wanted to start with a definition. Open educational resources are really anything used for teaching and learning. They could be text, they could be electronic. They're free, but what makes them special is that they're openly licensed. So unlike traditional copyright, you can do a lot of different things with those. We use the 5 R's to talk about them. You can revise, reuse, retain, remix, or redistribute. So unlike traditional things, you could slice and dice it any way you'd like.
Okay, so here's some numbers that help to illustrate the need and the need to think about textbook affordability broadly. Over the period of 2002 to 2012, we saw an 82% rise in the cost of textbooks. In Tennessee, that equals at present $1,528 that students are spending per year at 4-year public universities here in Tennessee, which is kind of a lot of money. One of the things that's interesting and is an implication of this is that lots of students are choosing not to buy required resources because of their costs. So a number of studies demonstrate that it's about 66% of the students who decide not to buy a textbook because of the cost. And the vast majority of those know that that's going to impact their grade, but choose not to buy the textbook anyways. And interestingly too, a lot of students are using textbook price or cost to determine which classes that they register for. So they're choosing to not register for classes that include expensive materials.
And these are just some of the large players in the nation for OER providers. Open Textbook Network, it's a group we hope to join, is out of the University of Minnesota. It's a repository for textbooks. You can review OER, find OER there. OpenStax is probably the most well-known. It's a nonprofit out of Rice University, and it's more of a traditional textbook operation, peer-reviewed, cover-to-cover textbooks. And then there's MIT Courseware, which is not textbooks, but more curriculum, like a lecture series, slides. But as you can see, they're all very popular, and they're saving students a lot of money. And so this matters to our students, of course, and this is not surprising, but our students are borrowing money to be here. And a lot of the costs that come with college are indirect, and that could make for financial insecurity because a lot of times the costs that they face at college are not what they're expecting. And as Ryan said before, a lot of times students have to decide whether or not they're going to take a class because of the cost of the textbook.
So excuse me, sorry. We're using OER on campus a little bit. In the program that I coordinate, our first year experience, or first year seminar course, we use an OER textbook, and we've been using it for 1 year. And so in the fall of 2018, we used a textbook from a major publisher, one that's used at a number of universities. It costs a student someplace between $55 and $75, which equaled a cost of someplace around $50,000 to $65,000 in the aggregate for all the students enrolled in our program. In the fall of 19, we switched and we used a OER textbook that had no cost to students, right? So we've saved, in this annual year, we've saved students at least $50,000 in using the textbook. But the thing that I want to point out to you now, let me go to the next slide. If you have a smartphone, this is the thing that I want to point out to you. If you can open your camera app on your smartphone and scan this little QR code, what you're gonna find is the textbook, right? This QR code will take you directly to the textbook that we're using in our University 1010 class. So you may have to zoom in on it a little bit. But the thing that I want you to notice is the quality of this material and the ease of access. As you open there's a little thing that comes down on the top of your cell phone that says open in Safari or whatever your web browser is. This is the slide that we can use. This is the access that OER provides us, right? Instantaneous access to high quality student learning materials. Students can have this on the first day, and they can have it at no charge. If you can pursue the website of this textbook, and this isn't a plug for this textbook, this is an example of what's happening with OER. But one of the things that you'll notice is that this textbook is available in a number of formats. It's available in HTML, it's available as on e-reader services or as a downloadable PDF. And we find that students are using all of these at the same time. Not one of the electronic formats, but all of them, and that kind of flexibility becomes an important resource and benefit for students. Okay, so in 2015, there was a interinstitutional study of about 16,000 students who were using OER materials. They were compared against students who were not using OER materials. And a couple of really important conclusions arrived, I think, or were derived from that study. The first is that the students who used OER materials registered for more courses or more credits per semester than students who weren't using OER materials. I think this speaks to the barrier nature of textbook costs to student enrollment. The other important conclusion from this study was that academic performance was relatively the same between all of the courses. Many of the courses showed a higher GPA for students using OER materials, but they were roughly the same. So what I think this indicates to us is that these are quality learning tools that are useful for students. There are moves towards OER in our kind of backyard and in our system. TBR is currently working on textbook affordability initiative. They're doing something that's similar to the Include Ed program that we had here before, and that's what they're advocating for. THEC is working on open resources. They're putting together a task force to figure out how to use OER in Tennessee. Both the TBR and THEC sponsored a textbook affordability summit this summer. And then I'll also point out that the University of Chattanooga Tennessee at Chattanooga is something of a leader in OER in Tennessee. They have a number of courses using open source material, and they've saved students at least $1 million because of open source textbook usage. So the next steps for us, we're doing some outreach. We're sending a survey to the faculty to find out more about faculty perceptions of OER and who specifically is using OER. We're pursuing some grant funding through OpenStax and then also through the MTSU Foundation or Special Projects Fund. And then we're working to develop institutional structures that will support this. And a lot of this work is happening in the library. And they've already done some really innovative things to support students and to help address the textbook affordability problem. And they continue to help us. We're also working to partner with Gen Ed Redesign, with the LT and ITC, and with other departments on campus to make sure that this is a faculty-led and quality initiative with wide approval. Okay, does anybody have any questions about OER? I know that's a lot of information. That's the last slide that we have. Yes?
I have a couple questions. You've mentioned the quality a couple times.
Yeah.
And I noticed the example you used, I think, was the University 1010 book.
Correct.
Does that quality run across all the disciplines? I know science is specifically one of the more expensive books. Are those
Right.
sciences on par with the brand name books?
Right. So I'm not a scientist by training, but so I can't speak with really a lot of authority there. But what I would say is OpenStax, that large OER resource, they put together vetted, peer-reviewed resources from any and all disciplines. And so their STEM textbooks have won awards. They're they're adopted by a lot of people, and everybody that I speak with thinks that they're of high quality.
I am a mathematician, and I have looked at the OE resources in mathematics, and they do not meet the quality.
So the other, but the other thing, I'm sorry,
adding new ones every day. So.
But the other thing that I would say has happened in the last 5 years is because OER has gained traction nationally, there are a ton of new OER resources that have been developed. So just like with any publisher, there are going to be things that work and things that don't. And I'm not suggesting for a minute that OER is a solution for every class, right? Just that it could be a solution for some of our classes.
And I think there's also a difference between freshman, sophomore courses and junior, senior courses. Junior, senior courses, there aren't as many textbooks out there, and there aren't as many people willing to write them for free. And so there is a lag between that. And so I think it's a very laudable and worthy goal, and I think saving the students money on textbooks is wonderful, but I don't think we throw the baby out with the bathwater, and if there's not an OER book out there, there's just not an OER book out there.
One other
Yes.
question. You said it included multiple different formats. Does it also include access codes? I know that's a lot of, sometimes teachers don't necessarily want the textbook, but they want the almost as equally expensive access code.
Right, so the access code usually allows students access to a homework system, which allows them to take practice problems and do self-graded assignments. So that is usually a system that's built by a publisher. So at the forefront of what's happening in OER right now is those kind of homework systems are being built. OER kind of takes a different tack when it comes to pedagogy, and that's a different thing. So it would correlate in some ways with what we call open pedagogy. And in general, the open pedagogy movement is kind of anti those self-graded assignments, and they want something that's more interactive and more personal. So sort of is the answer to it, yeah.
And the third piece of the puzzle is the instructor resources.
Right.
Usually publishers put a whole lot of
Correct.
effort into support of instructor resources. What's the situation with that in OER?
Yeah, so what happens, and I would use UT Chattanooga as an example here. So what they've done is they've invested in instructor development, and so they have a grant program where if you want to adopt an OER material, you can apply for a grant. You get support from a course designer and a librarian to help you find materials and then develop content that'll fit your students. So it's not a external support, it's a internal support almost.
Which
and
is
from
a
my
transfer of
perspective,
cost, but
it's a different,
still
yeah, it's a
cost.
transference of cost, right? It's a different way of doing cost, but it's also a different way of valuing the students who are in the classroom and looking at those students, not students nationally or in a large aggregate.
Are the OER resources much more utilized by online classes than by in-classroom classes?
That's a good question. I haven't seen a study that suggests one way or another. My impression casually is that they're probably more used face-to-face than online, but I could be completely wrong with that.
I could add to that that's going to be discipline specific
Yeah, I would
also.
imagine.
Because for an online math class, part of the major bulk of the class is the practice problems, which no faculty member can write in one semester. So we usually rely on the publisher. So in math, the distance learning would generally not be amenable to OER unless there were free OER
Practice book.
Auxiliary
practice problems,
materials.
but the problem with that is also the grade security. We had a lot of conversation about if I use the Pearson level product, are the student grades protected by FERPA? Because I, as an instructor, decided to use the Pearson products, and that got us in a lot of weeds. And so if OER came up, if an OER source came up and said, here's a lot of practice problems, could they be graded? Does state law allow such kind of records to be stored in those particular non-associated kinds of servers? So right now, I would say distance learning and practice problems aren't fully resolved yet legally. That would
Some of the OpenStax textbooks do come with auxiliary materials, like problems and things.
Well, do they have the graded problems or just the problem lists?
That I can't tell you,
Yeah, so
Mary.
They're working
there's-
towards graded stuff.
Yeah,
Because
the
that's very
graded-
common, and that's very commonly utilized.
As legal knows, we went around and around in circles for 3 years, I specifically with legal, trying to figure out the protections for the faculty
Right.
under FERPA, using external sources.
Right, and I would
that's
say that
still
that's a
not
problem
ironed
that's
out.
not confined to distance learning, because
I agree.
we do a lot of stuff with electronic
The only
resources
problem-
in face-to-face and distance.
I totally agree. The only problem is with distance learning, your only recourse is to use the graded off-site. If I'm in a face-to-face in a classroom, I can construct my own grades, keep the grades in D2L, construct my own assessments. If I'm distance learning, I can't do that directly the same way. So it has more impact in distance learning.
Well, there.
It's in the weeds,
Yeah,
sorry.
there's still some issues involved with this, but this is overall a very exciting development in higher ed, and we're looking to maximize our use of it. So thank you.
Thank you.
Let me ask Ryan.
Yes, sir.
Yeah, I know you said the library's involved.
Yes.
You didn't mention bookstore, which is old school, I know.
That's a
You
good
didn't
question.
mention that. And how in the world do we let new incoming freshman students and student body students know about the OER that's available currently? How do we
Right, okay, so-
broadcast that?
Let me take your questions in reverse order.
Yeah.
So first about student access. Currently in the system that we have, professors select required materials for their classes. So the approach that we're trying to take is to inform faculty. So faculty select OER materials that are high quality and then pass those selections on to students. So we do need to think about helping students to know that these things are possible, but students aren't in a position to decide what textbooks they use in their classes. So
We need to convince
we need to do both, but we've put our efforts with faculty, or that's where we're thinking now. And
Can I answer the
yeah,
bookstore
go for it.
que- I'm Suzanne Mangrum for the library. We work very closely with the bookstore. We use them for our textbook affordability program, and they have met with the group Cheryl has convened, Jeff Whitwell from the bookstore. They have been a part of this. They know it's important, and actually, I depend on the bookstore for the course list. So they usually let me know when there's an OER class, because they're the source of that full course information.
Thank you very much for a very good report.
One other question.
Yep.
Where appropriate, or in what courses where it's appropriate, how do we, what's the obstacle to moving this forward faster?
I think the obstacle is so I'll speak from the transition that we made from non-OER to OER. So we had to develop new assignments, we had to develop new PowerPoints, we had to, right? It's all those ancillary things which take time to build, and you're basically redesigning and reconstructing a class. So it's just it's a startup time, right? And so that's what it is. The obstacle is the time to redevelop course materials and to redesign a class so that it incorporates a new textbook. It's the same operational delay, I guess you could say, as when textbooks change editions, as when we move from one traditional product to another traditional product.
It sounded like UT Chattanooga was ahead of the curve.
They
Is
are.
there any way to piggyback on them and speed up the process?
So they've done some grants to individual faculty members. They do 10 grants. They grant 10 faculty members a year some supplemental money to redesign their classes. And from the sounds of things, they have more people willing to redesign classes than they have money available to grant to them for the time and the support to do it. So that would be a mechanism.
What would be the cost of a grant?
I believe that they're doing grants of someplace around in the ballpark of $1,000 to $3,000 for a faculty member.
So not a lot of money. So could we not in our budget, Mr. Chairman, whoever this is directed to, find some money to grant fund this to move this forward faster to reduce
I think
cost to students?
the answer is we should ask Mark to see if he can't talk Alan into getting it in the budget. Right, I mean.
Yes, sir.
And for Joey's
Doesn't
committee
sound
to
like a
look-
lot of money.
Well, you know,
It sounds like peanuts compared to the cost savings.
Alan can be very difficult, of course, but no, Alan's very supportive of what we do in academic affairs, and
That's
we're-
pocket change.
we're pursuing a
Alan.
couple of grants, so we'll figure out the funding source one way or the
And
other.
could we have this as a kind of an ongoing report as how this is coming? I mean, this sounds to be pretty important for students.
Absolutely.
Be glad to.
Absolutely. Thank you for a great report. Thank you.
Great report.
If there is no other business, thank you for a spirited committee meeting today, and I would entertain a motion to adjourn this committee.
So moved.
We're going to
Second.
start the next meeting in 5 minutes.
Right on.